beautiful day out. It's a sunny day. All right. You ready, Jason? We're going to get started. You ready? Director Paul, are you ready?
Yes.
Great.
Got it.
Good morning, everyone. Welcome to the February 14th, 2017 meeting of the Oregon Land Board. I want to say first a welcome and congratulations to our new Land Board members. To my right, Secretary of State Dennis Richardson. Congratulations and welcome aboard.
Thank you.
You want to introduce your assistant?
This is Steve Elzinga, who is my assistant on government and legislative matters.
Great. Welcome to you both. And to my left, our new state treasurer, Tobias Reed. Welcome.
Thank you, Governor.
You want to introduce your assistant as well?
Thank you. Chelsea Broussard has been a talented and key part of our team in the legislature, and I'm glad to have her as our policy director in the state treasury.
Great. Thank you. Well, happy Valentine's Day to everyone, and it is also Oregon Statehood Day, so hopefully that is a wonderful beginning to the day. So, Director Paul, turn it over to you for the consent agenda.
Thank you, Governor Brown, and welcome Treasurer Reed and Secretary Richardson. My congratulations and welcome to you as well as our two newest Land Board members.
Can I just do a mic check? Can everybody hear Director Paul? No. Okay.
Sorry, I seem to have that issue every time.
Okay.
How's that? Is that better?
Is that better?
All right.
Pretend it's an ice cream cone.
Just keep you guessing. So the first item on our agenda is the consent agenda. And there are two items within the consent agenda. The first one is a request for approval of the minutes from the December 13th, 2016 State Land Board meeting. And the second consent agenda, item 1B, is a request for approval to initiate the review and determination of the potential sale of approximately 40 acres of state-owned filled lands in Multnomah County. On the second consent agenda item, this is originated from an application the Department of State Lands received from Campbell Isaac Kidd for the purchase of approximately 40 acres of state-owned lands on Sauvie Island, which is just to the south of the Sauvie Island Wildlife Management Area. The applicant owns land adjacent to the parcel. Upon approval of this agenda item, the department will initiate due diligence, our due diligence process, including sending letters to adjacent landowners and lessees, local, state, and federal agencies, and tribal interests. Any significant concerns identified as a result of the public review notices will be thoroughly evaluated and thoughtfully considered prior to moving forward with a recommendation on the sale process. And this would require, upon conclusion of this due diligence, it does require another visit to the Land Board if the department is to recommend sale. So again, this is just to initiate our formal due diligence process to evaluate this potential sale. And the recommendation of the staff is to approve the consent agenda.
And there was no opposition to item B, is that correct?
That is correct, Governor.
Thank you. Any questions? Do I have a motion?
Madam Chair, I'd move approval of the consent agenda.
Treasurer Reed moves approval of the consent agenda. Is there any further discussion? Any opposition? Hearing and seeing none, so ordered.
Okay, thank you, Governor. Sorry, I'm turning my finger off here.
Your phone off?
My phone off.
So your mother doesn't call during the meeting?
Right.
I left mine in the Capitol in case she calls, so.
So moving on to our action items. Item number 2 is a request for approval to grant a 20-year easement for a fiber optics communication cable across state-owned submerged and submersible lands in Oregon's territorial sea. The department received an application from Microsoft Infrastructure Group proposing to install a new Trans-Pacific undersea fiber optic cable system linking the United States to Asia. They have proposed a $300,000 payment to satisfy the just compensation requirement for the use of state-owned lands and for the initial 20-year term of the easement. The department has circulated the application for public review and received one comment from the Oregon Department of Fish and Wildlife, and it was around the timing of the proposed construction. and it encompasses the typical timing of the state endangered gray whale migration in the area. ODF&W recommended that construction activities in the ocean be conducted outside of that window to the extent possible, and for activities required during the migration window, procedures be in place to monitor the presence of whales and delay or suspend operations while whales are in the vicinity. Microsoft Infrastructure LLC has addressed these concerns, and I believe there is a document to that effect in the agenda item itself. So our recommendation is for the state landlord to approve the granting of this 20-year easement for this fiber optic cable, communication cable across state-owned submersible lands within and adjacent to the territorial sea, landing near Pacific City in Tillamook County.
Thank you. Questions? Okay. My understanding is that Commissioner Terry Thompson is here and is asked to provide public comment, and I'd like to ask the Commissioner to come forward.
Thank you. Today I'm representing the Oregon Fishermen's Cable Committee, which Scott McMullen and I started. He's in Hawaii, and he asked me to be here and make a couple comments.
You drew the short straw.
Yeah, I did on this one. So back in July of 2015, Microsoft contacted the Oregon Fishermen's Cable Committee. And since some of you are new to this process, we have a great relationship between undersea cables and the fishing industry. We actually have fishing boats working together to bury cables in the mud so that we can fish over them, unlike a lot of places in the world. And since we came in existence, there's never been a cable break off Oregon. And the cable companies come here now automatically because the people who lay those cables say we're the best place in the world to come. And in this case, the fishermen from the Columbia River, the trawlers from the Columbia River in Newport, laid out the route so that it could be laid in the mud almost all of the way. There's always a couple of problems. In this one, there was a couple of pock marks out in 250 fathoms. The pock marks are caused by bubbles of gas that come up, and they look like spots on the moon. And it's one of those things that we run into. We've tried to go around them the best we can. We'll see when we actually lay the cable. But the company, Microsoft, has been great to work with. And in March of 23rd of 2016, they signed an agreement. They actually become a board member of the Fishermen's Cable Committee. And it's a good, positive thing for the state of Oregon. We look forward to working with them. And thank you very much for your consideration.
Thank you, Commissioner Thompson. Any questions? Great. Is there a motion on the staff recommendation?
I'm sure I'd move approval of the request for.
Treasurer Reed moves approval of the staff recommendation that the State Land Board approve the granting of a 20-year easement to Microsoft Infrastructure LLC for a fiber optic communication cable across state-owned, submerged, and submersible land within and adjacent to the territorial sea, landing near Pacific City in Tillamook County. Is there any objection to the motion? Hearing and seeing none, it's so ordered. Item number 3.
Okay, thank you. Item number 3, also an action item. This is a request for approval to quitclaim approximately 1.54 acres of submerged and submersible land to the Marine Salvage Consortium in Multnomah County. This agenda item dates back to June of 1967, when the state deeded its interest in certain submerged and submersible lands within the Swan Island Lagoon to the Port of Portland for development purposes. In March of 1973, the port then sold the property. The property was subsequently sold again in June of 1993 to the current property owner, the Marine Salvage Consortium, Inc. Even though these transactions, these were all lawful and acknowledged transactions at the time, what we recognize in looking back in the record is that those transactions and the ownership that occurred as a result of those transactions was never clarified in terms of the transfer from state ownership to the original owner that then subsequently transferred it. What this quitclaim will do is this quitclaim action will clarify and formalize acknowledgement of legal ownership of the submerged and submersible lands between the line of ordinary low water and the line of ordinary high water at this location. Both department staff and attorneys working on the Portland Harbor Superfund cleanup effort agree that an exchange of quitclaim deeds with the Marine Salvage Consortium will mutually benefit both parties. The recommendation is that the State Land Board approve the granting of a quitclaim deed to the Marine Salvage Consortium, Inc. to clear title of the state's ownership of the submerged and submersible lands at the surveyed 1973 mean ordinary low water line.
Thank you. Any questions or comments? Is there a motion?
Madam Chair, I move approval of the request.
Treasurer Reed moves approval of the staff recommendation that the State Land Board approve the granting of a quitclaim deed to the Marine Salvage Consortium to clear title of the state's ownership of the submerged and submersible lands at the surveyed 1973 mean ordinary low water line. Any discussion? Any opposition to the motion? Hearing and seeing none, so ordered. Thank you. Director Paul, before we move on to agenda item number 4, I understand that the Senate President is here, and I'd like to ask him to come forward.
There you go.
Mr. President, come on up. The floor is yours.
Mike is yours, but hold like an ice cream cone.
Commissioner, Your Honor, Thompson, is he allowed to speak from here?
Yes, Commissioner Thompson was allowed to speak from here.
I was heard I was supposed to speak from way back there.
You're special. We're going to let you speak from up here.
My name is Peter Courtney, and I'm a state senator in District 11, which is Salem and Jervis and Woodburn. This building is in my Senate district. And I'm also happen to be the presiding officer of the State Senate, but I'm not here, Your Honor, to talk about, to speak on behalf of the Oregon State Senate, Democrats, Republicans, or the legislatures and such, but you know, I never realized that the State Land Board, it's the most difficult job you have. Treasurer Richardson, and, Secretary of State Richardson, Treasurer, Vice President Governor Brown, because you can't talk to each other. And what I'm about to say is I don't like it when people come and tell us how to do things in the legislature from other jurisdictions. So if any time what I'm about to say offends you, please let me apologize, because each of you is much better and more talented than I am in all areas of governance. It's just that I come here today to try to help, and you're going to find that maybe difficult to understand. I'm not here today to talk about an elaborate plan for the Elliott State Forest. I'm here today to simply that I believe that the Elliott State Forest should remain in public ownership. I believe public ownership is the only way to guarantee the necessary protections of the sensitive, fragile elements of Mother Nature that exist there. The Elliott is held in trust now for the Common School Fund, for future generations of our Oregonians, for our children and grandchildren. Whatever plan emerges must be faithful to that trust. And I'll finish my statement here by saying I will offer one specific suggestion that I'll work very hard on should you choose to go there. If any bonding is involved, I would ask that you look at revenue bonds. A treasure like the LA State Forest doesn't come along every day. Now let me just speak in an everyday way to you. When I say revenue bonds, and all of you who served the legislature know what that means. I have to identify a source of funding to pay for those revenue funds. It has to come from the property or the building. It's not like general obligation bonds. You all know this much better than me. So basically I'm saying something has to come off that site to pay for these revenue bonds. But I just offer that as a way to deal with this. Now I also want to admit to you that a good faith effort has been made by the private sector, and a good faith procedure was set up for the private sector to bid on the property. I don't want to second guess any of those here that were involved in that. This is a very difficult, sensitive issue. The only reason I came here today is to say that if I can help in any way with this situation, and whatever decision you make collectively, you make. That's, of course, your responsibility. But I did not come here today to throw a monkey wrench or whatever kind of wrench you call it into this, but rather try to help. The bonding issue was mentioned, as you well know, but I think it was pretty much talked about lottery bonds, etc. I don't know if that's possible or not, only because we have a very limited amount of lottery bonds. Revenue bonds I've used to help on a number of projects in the state, and that you all know, because I'm looking at individuals who've served on Ways and Means and are much better on Ways and Means than I am. So that is the only reason I've come here today. The Senate Democrats have not sent me here. The state Senate has not sent me here. The Speaker nor the House Democrats, Republicans have not sent me here. I've come in an effort to try to deal with this, and I'll defer to your wisdom individually and collectively. So that is why I've come here. And I thank you for even allowing me to come and speak to you. I've never before the State Land Board. I've never before been in this building. I have often wondered what the State Land Board was really like. And I can't say I feel a lot of warmth right here now, and looking at the eyes and the body language of some of my fellow legislators, since I've served with all of you. So, again, I didn't come in here to second guess you. If that's what you sounds like, I apologize. I didn't come here to tell you I'm the smartest kid in the class. I've never been the smartest kid anywhere. I didn't come here to mess things up, and if I'm doing that, I apologize. My parents ever made me. But I am here to say if I can help in any way with revenue bonds, then I will try as hard as I can to help you individually and collectively with this most difficult situation. And I didn't know until just very recently, Your Honors, that you can't talk to each other. And I should have known that because I talk to everybody. And that probably means Dennis is a very good lawyer. Dennis Richardson, an extraordinary lawyer. He's about to sue me for violating the Open Meetings Law. But so because I can't believe it. I know you all as individuals, but you can't even look at each other here. So I'm very sincere about this. And that's why I've come. Humbly, I mean it. So I don't know if I can help, but I would ask you to consider that. But you're very kind to even let me come and speak to you. And to the extent I've interrupted your proceedings here, I've been pushed ahead. I didn't mean to be pushed ahead of all the people back here who want to talk. I didn't mean that at all, Your Honor.
Thank you, Mr. President. Secretary Richardson, any questions? You don't have to.
Well, I have one, but I don't know if Senate President could answer it, but that would be if there were revenue bonds, they have to be paid by revenue generated by the source that the bonds are used. And so I'd be interested in knowing what the source of revenue would be that would pay for such bonds.
Governor Brown, Secretary of State, that, of course, you deals with the logs. You could deal with any kind of park situation, any and all. You'd have to look at any and all because you're absolutely right. Once I say revenue bonds, you're absolutely right. It's got to come from that site. It can't, as far as I know, Your Honor, and you're smarter than I am, the site has to generate that money to pay off those bonds. So you're exactly right. And I did not design that as to exactly how to pay them off, but I fully admit once I went down that route, I was admitting fully that there's going to have to probably be some logging, et cetera, to go on there. But some revenue has to be generated from the site to pay off the bonds. It's just an easier way to go when you're up against general obligation bonds, in my opinion, or lottery bonds, given this. And as you know, that's all I'm saying. And I have gone to revenue bonds before, Your Honor, when we were in this situation when we didn't have enough. Some of it's, we do higher ed, that's how we build the residence hall. You all know that thing. And this is different than residence halls, but it's the same kind of thing. The money has to come from the site itself.
Treasurer Reed, any questions?
No, thank you for coming, Mr. President.
Thank you, Mr. President. We appreciate your time and energy. Appreciate your service to the state of Oregon.
And by the way, did you know, since I'm wearing red, and it's Valentine's Day, and I want you to know that this tie was given to me by the Republicans. It's got elephants on it, but really I call it my Packy tie, Packy, the elephant zoo. So happy Valentine's Day, Oregon. Happy Valentine's Day. Thank you very much.
Thank you, Mr. President. All right, I'm going to allow the clapping for this one, but after that, please use your jazz hands, your silent hands. Thank you. And we're going to move on to continue our work on number 4, the Elliott Property Ownership Transfer Opportunity Status Report. Director Paul.
Great. Thank you, Governor Brown. So moving on to agenda item number 4, an informational item regarding the Elliott Property Ownership Transfer Opportunity Status Report. I think I will keep this, my presentation at least, relatively brief. I think before you have a fairly succinct staff memo around the work that we have done since we last spoke on this topic in December. In that memo, you'll see a very brief summary of some background. You'll see a brief summary of the work that's been done since December. And from the department's, the direction specific to the department, that was to essentially work with the proposers to clarify some gaps, ambiguities, and uncertainties and report back to the board today in this update. We have done that work with the proposers over the course of 3 separate meetings. We have clarified those gaps, uncertainties, and ambiguities and confirmed that the proposal is sufficient to demonstrate responsiveness. And you'll see in the next steps, per the protocol, the next steps would involve initiating negotiations in good faith with the proposers and moving forward per the terms of the protocol, unless and to the extent the board directs the department otherwise. I'll stop there and will be happy to elaborate on anything in the report and answer any questions, and we'll turn it back to you, Governor, for direction.
Thank you, Director Paul. Questions or comments from board members? My question will be, Director Paul, in terms of the protocol, it's my understanding that if we were to move forward on the protocol, that the only option we could consider under the protocol is the one that was submitted to us. Is that correct?
Governor Brown, under the current terms of the protocol, which include the supplements that were adopted, that were put in place over the course of the protocol, the next steps in the protocol as it sits right now, again, unless directed otherwise, is for the department to initiate negotiations towards signing a purchase and sale agreement in good faith with the intent of executing the sale. And the protocol, as currently written, would not call for this issue returning to the board at a future time.
And could you talk to the land board members and the public and share a little bit about what has changed since we made the decision to enter into the protocol in terms of the Elliott from your perspective and the department's perspective?
I'd be happy to, Governor. So it's been maybe 18 months, I believe, since August of 2015. There was a year and a half almost of work that led up to that date and the information that led to that decision. That is all, hopefully you've all a chance to see that work, at least look at some of that work in the number of reports and due diligence that the department has done. I suppose at the risk of not getting into speculation or sort of value judgments about things that have changed, small or large, that might or might not impact your decisions, I think I would just mention maybe 2 factors that may be most germane to the set of facts that we had in August of 2015, and they're probably very obvious, be no surprise. In August 2015, we believed our best estimate of the value of the property was something between $280 million and I believe $410 million, if I remember those numbers right. And we took the midpoint of that range, and often quoted, you'll see at the documentation leading up to the appraisal work, was a 360-some value that we estimated for the property. That was the value, our best guess. I believe it was a very robust guess, just given the cursory nature at which we went about doing that. But nonetheless, that was the number that we used amongst the analysis and all the work we did. In July of last year, we completed a very thorough appraisal process. We had a timber cruise of over 18,000 plots. My understanding is that it's extremely extensive. not unprecedented, but a relatively unusual level of intensity of timber crews. We also contracted with 3 independent appraiser firms, which each appraised their own independent value, which was then delivered to our appraisal consultant, who then took those appraisals and determined a single appraised fair market value for the property. That amount was announced in July of last year, and that amount was $220.8 million, the amount that has been on the table and that the proposers have included in their proposal. So, to me, that's a notable difference in information in terms of what that means of your decisions. I'll leave that to you, the 3 of you, to determine. But we went from a belief that it was worth $360 million to a very robust, I believe, defensible appraisal that tells us it's worth $220.8 million. Other than that, Governor, I think I would only other thing I might say that in terms of the most significant change, maybe just the notion of the idea that's now on the table of potentially up to $100 million in bonding. Up to this point, we didn't have any idea like that on the table in terms of our conversations about options and potential scenarios.
And then 2016 saw something different on the Elliott than we've seen in the last couple of years. My understanding is that we've seen a net revenue gain off of the Elliott.
In 2016, we have our preliminary numbers right now. So just to give you some context, Governor, yes, you are correct. And to give you some context, we have the Department of Forestry report every year, an annual report of what's been accomplished on the Elliott, actually on all of the common school forest lands, which include the Elliott. We typically provide that report to the land board in the spring, and we're slated to bring that to you in April. So while we don't have that finalized report prepared, are the initial numbers that we have been told from forestry estimate that there is a positive revenue stream that we saw this past fiscal year for the first time since 2012 of approximately 1.3 something million. I have that number in front of me, correct?
Thank you. So I'm going to make a couple of comments, and then I'll turn it over to each one of you for comments and or questions. So as we move forward on this process, and I see this as a process, I want to continue to make sure that Oregonians have an opportunity to have their voices be heard about the outcome of the Elliott. I do want to reiterate my appreciation and sincere gratitude for the proposal submitted by Lone Rock, the Cow Creek Band of Umpqua Indians, the Confederated Tribes of the Coos, Lower Umpqua, and Siuslaw, and to the Conservation Fund. However, having heard from many of you over the last couple of years, and after a lot of deliberation, it is clear to me that it is in the best interests of Oregonians to ensure public ownership of the Elliott State Forest for future generations. The appraised value of the forest was surprisingly low at $220 million. We don't know what the future holds, and I think that retaining the Elliott as a state asset is the proper exercise of the fiduciary responsibility of the state. Public ownership protects public access, which is critical for Oregonians, whether they be children at outdoor school, hunters, anglers, or hikers. The protocol only produced one proposal. We had hoped, frankly, to compare proposals, but ultimately we could not. In conversations that I have had since the proposal came out, it was clear to me, at least in the conversations that I had, that the terms may have been too restrictive and the timeline may have been too short. But certainly the process did not lead to the results that I had hoped for. I certainly know that Lone Rock and its partners worked very hard on this proposal for a number of months and invested in it, and we appreciate very much their good faith. I think it's fair to say, from my perspective, the importance of state-owned land has increased as the future of federal public lands has come into question. We also know that Oregon is still not on track to meet our climate goals, And some of you may have read recently the report from the Global Warming Commission. I commend it to you for nighttime reading. But it shows that we are missing greenhouse gas reduction targets. I think that growing forests are an important carbon sink and something that Oregon does very, very well. Even in the face of complicated challenges, I believe we must strive to protect the values we hold dear. To do so, I support the Elliott State Forest remaining in public ownership, with either the state or the tribes owning or partnering to own the land. The proposal that I have put on the table includes up to $100 million in state bonding capacity to protect critical habitats, including riparian areas, steep slopes, and old growth stands. The Senate President came forward with a specific proposal. I want to make sure that we keep all of our bonding options on the table. The investment would go toward the Common School Fund, and most importantly, as we've heard over the last couple of years, decouple a portion of the forest from the Common School Trust lands. On the remainder of the forest, what I would propose is that we enter into negotiations with the Federal Services for a habitat conservation plan to allow for sustainable timber harvest while protecting endangered and threatened species. Under this proposal, I think the expectation is to average about 20 million board feet per year over the long term, though we know, as the director mentions, in certain years these numbers fluctuate. But I think that is a rough goal that we can work towards. I am also hoping, I think many of you know that I've had the incredible opportunity to serve and work with the tribes as a member of the Commission on Indian Services. And I'm very committed to working with our tribes to partner with them to manage their ancestral lands while protecting the Common School Fund. At this stage, I believe we need to end the protocol while continuing conversations with the tribes, Lone Rock, and others about the future of the forest. I certainly look forward to discussing the approach I've outlined to retain public ownership of the Elliott and protect the Common School Fund. But while I chair the State Land Board, I am only one of 3 voices on the board. I recognize that my fellow land board members have much to add to the conversation, and I certainly look forward to hearing their perspectives and welcome them to this conversation that has been an ongoing conversation now for over a decade. So, thank you. I'm happy to turn it over to either one of you. Treasurer Reed.
Thank you, Madam Chair. I had a couple of questions. First, I wondered, Director Paul, if you could describe, you mentioned that there was a revenue gain in 2016, or at least that projection remains. Could you describe a little bit to what you would attribute that and why that's occurred?
Governor Brown, Treasurer Reed, I'd be happy to with the caveat that right now it's because we haven't actually
a projection then
gone ahead and sort of completed the report with all the details. It's somewhat speculative, but I can tell you what sort of my guess is, given just my familiarity and given with my knowledge of the last few years. At the start of fiscal year 2016 is when the protocol was approved. And at that time, then, we needed to start discussions with the Department of Forestry, who has been managing the Elliott since the 1950s for us, around what does that mean for them, potentially assuming the protocol were to result in the ownership transfer. So we had sort of a projected end date at which time the forest we would assume would no longer be managed. And at that time, too, we had a discrete number of timber sales we knew that were still possible to carry out under the current management approach. Prior to that decision, the modeling that we had done and the modeling that you will see in some of the reports leading up to August 2015 showed a real low, sort of a tail of up, positive, negative projected revenues hovering around zero, as the governor mentioned, that can fluctuate year to year. That modeling was before any decision was made about a potential transfer, where those sales that the Department of Forestry believed they were still able to execute, they essentially assumed those would be spread out over time. What I think explains part of that result, but again, I'm not positive until I look at those sales, is that once we realized we were potentially a couple of years away left, and given that the preceding 2 years were negative revenues, the department made an effort on DSL's request to ensure we can get back into the positive, to look at the sales that we can, and I believe there was somewhat of a compression in terms of trying to load more sales earlier. For example, we actually have a firm date currently around all existing timber sale activity to complete by next month. Again, this was decided about a year ago as we were operating under the assumption around the protocol schedule. So I think that's part of what's going on. Another scenario that might be going on is on the Elliott, the nature of those timber sales, $1.3 million can equate to 1 or 2 timber sales. That's how much value can come out of timber sales on the Elliott State Forest. And given the complexity of that forest, sometimes we will see a sale that's planned to go through that for unexpected reasons doesn't go through because of issues that arise during the sale process. So, 1 or 2 sales can sometimes make the difference between a positive or a negative. So that may be another issue going on. We happen to get a couple more sales or able to get through that issues didn't come up, and it resulted in a positive year.
Madam Chair, may I ask another question? Thank
Of course, Treasurer Reed.
I wonder, I'm just thinking back to the legislature where there's always a question. I ask for a follow-up of the chair, so I wanted to make sure.
I think
you're
that's
doing it
fine.
right. Thank you. I appreciated, Director, your the conciseness of your memo, but I wonder if you could elaborate a bit more on the gaps, uncertainties, and ambiguities, and how you handled that, and where those feel like they are at this point.
Certainly, Treasurer Reed. I think the primary area is actually there, and it was in all 3 of the 4 public value pieces that we looked at. We wanted to confirm the situation with public access in the proposal. We wanted to confirm the situation with older forest structure. Thirdly, the riparian area protections, and finally, that encompasses all of them, the enforceable mechanisms. In the proposal originally, there were statements about keeping at least half of the forest open for public access, so speaking to the public access piece first. And there were also statements about the intent to, there was a map, I guess, that showed the entire forest open to public access. And we wanted to clarify what exactly was the commitment of this proposal to ensure public access. And to without reading directly from the report, to paraphrase, the bottom line, in their addendum, you'll see there is a commitment to meet the protocol requirement to at least ensure in perpetuity at least half of the forest public access. And there's additional intent on their part that we heard during these conversations to our expectation that there would be access above and beyond that. But in terms of the legally binding piece, it was clarified that they would agree to legally binding that threshold of the protocol. That was the public access. On the older forest structure, there was some mention in the original proposal around the ability to review where those older forest stands are protected and potentially those moving over time. That obviously creates some concerns around wanting to have assurances that there will be a minimum number of acres always in that condition. So we need to clarify with them around what their intent there, and we actually received some additional language from them around how that they would intend to define in a measurable way what that older forest structure is that is then verifiable and enforceable to show that at any point in time in the future there is always that type of habitat of that 25% of the forest. And that there would have to be a conservation easement in place that was enforceable that would guarantee that. So in the event in the future the forest were to grow 30, 35, 40%, it may allow some management of what's above and beyond 25%, but there would always be the functional older forest structure of 25% on the forest. So we did clarify that. The third piece around the riparian areas, that really came down to ensuring that the riparian protections do exceed the Forest Practices Act, as we stated in the protocol. And specifically, it came down to what would happen beyond 100-foot buffers, where there are 100-foot buffers, because currently Forest Practices Act riparian areas do not extend beyond that. And we did confirm that their proposal would provide additional retention in those areas that would be riparian retention and wouldn't simply be, say, a Forest Practices Act level of retention just provided within 100 while calling it 120 just to be maybe overly blunt. But we confirmed that their intent was to go above and beyond the Forest Practices Act and actually apply retention standards proportionally where that requirement is to go out to 120 feet. Finally, on the enforceable mechanisms, we did come to agreement in concept that to talk about the ability and a mechanism to build in to have somehow the state have the ability in the future to step in if and when appropriate and take action to ensure that the easements that would provide for these public benefits would be enforceable. The original proposal did not articulate that. The original proposal did have third-party conservation easement holders, but did not indicate any kind of third-party or public ability to enforce. So that was one we had maybe most conversation on, but we did work through the concept. Again, much is left to if we were to move forward to negotiate how that language would look and what's legally feasible. But the principles, I think, are in place there to ensure that the department would not move forward unless we felt, with Department of Justice advice, that it was in fact enforceable and the state did retain the ability in some form to ensure that those protections, those benefits are provided in perpetuity. I think I'll stop there.
Thank you. I might offer my perspective is I've been thinking about this a lot, obviously, and spending a lot of time talking with a lot of experts and a lot of people who've been involved in this. I think what we are really struggling with here is a question of essentially how to protect the public interest, and it's a question that is one we have to simultaneously protect the public interest and meet our constitutional obligation or fiduciary obligation to the Common School Fund and Oregon school kids. For me, this question of public ownership is really a proxy of public interest, and as I've thought about it, it's a question of what that means. For me, it's access first. Is there a guarantee that the public can get on and use the land in lots of different forms, hiking, fishing, hunting, just being there? And second, a question of conservation. How do we maintain that ability for people in the future? Third, for me, one of the most important ones is our very specific constitutional obligation to managing trust lands in a way that benefits school kids now and in the future. And fourth, often forgotten, but I think certainly not least in this list, is whether we have an opportunity to right some historic wrongs in terms of restoring land to our state's native peoples. So is there a way to balance those competing interests? And that's what I've really been struggling with. That brings us to this question and this process that the previous land board initiated. I was obviously not a member of that process or that land board, but I'm asked now to assess that process. And when we're here at this step, each time that the department in the process came back to the land board, and the land board affirmed that process and its continuation, I think it was affirming that this process was the best way to attempt that balance. At any moment, that land board could have taken a different path, but it didn't, and I suspect that is because the land board realized this direction we have. The language that the Attorney General uses is to exercise an undivided loyalty. Those two words have really stuck with me to the fund's beneficiaries, the school children. So I feel really strongly that when we have this proposal in front of us, not one that is everything to everyone, but is responsive through a significant process and the land board's work and the the department's continued discussion around gaps, uncertainties, and ambiguities, I can't simply cast it aside. I think it is the best and most realistic proposal that we have in front of us. I say that recognizing that all three of us are former legislators and recognize the various claims on our bonding capacity. So I'm going to, the first half of this sentence should not outweigh the second half of this sentence. I support moving forward with the protocol, but I have some ideas about some additional requirements that I would like to propose for our consideration. And to make it official, I guess I need to put this in a motion. So I would move that.
Before you make that motion, I just want to inquire with the director of the state lands to confirm that we have an ability to change the protocol that's currently on the table.
I may need to turn to my legal counsel on this. I can tell you for sure.
Let's take a little recess then.
Okay.
I'm going to take a 5-minute recess here, maybe a 10-minute, depending if you need longer.
Okay.
So, thank you.
Thank you.
You don't have a director?
We're giving you a little extra time today. All right, we're going to go back on the record. Again, it's February 14th, 2017, where you've got the full complement of the land board in front of us. Director Paul.
Thank you, Governor Brown. So I believe we left before recess with the question of if it is the land board has the authority, there's the authority to amend, supplement the protocol. And I said I need to consult with my counsel, and so I'd like to actually turn it over to Matt DeVore to offer the response to that question.
Governor Brown, yes, the land board can amend the protocol. As you know, it was a fairly lengthy process of drafting that document and went through considerable scrutiny from DOJ as well as the land board and various consultants that helped to draft the protocol. So yes, it can be amended. The concern that I would have is that I'm not aware of what the amendment is, and any language that is in the amendment, there is the chance that it could be internally inconsistent with the protocol. So what I would suggest is that if an amendment were agreed to, that it also include a statement that gives the director the authority to use his discretion to reconcile any possible inconsistencies or anything that may contradict the terms that already exist in the protocol.
And Mr. DeVore, when you said the protocol was developed after careful consideration and extensive consultation internally within the Department of Justice, in terms of period of time, could you give us it was a ball game, couple of days, couple of weeks, couple of months?
Months.
Okay, thank you. Treasurer Reed, I believe the floor is yours.
Thank you, Madam Chair. I would like to accept that suggestion and be clear that the amendment that I'd like to propose would certainly go with the intention of leaving to the Department the discretion to reconcile and integrate these concepts in the way that would be consistent. So with that, and again, just since we've had a long break from my original statement, I don't propose these out of anything other than a sincere attempt to balance what I view as competing interests in maintaining public interest and in living up to our very specific fiduciary obligation and required undivided loyalty to Oregon's students. So to recap briefly, I am proposing that we continue with the protocol and include in any negotiated purchase and sale agreement the ability for the state to repurchase by June 30th, 2018, or up to 90 days after a transfer was completed, up to $25 million in acreage land from the LLC for key conservation habitat. And if the legislature does approve those funds, I would like to see that that acreage in a conservation structure that would allow continued access for recreation, hunting, angling, could be in the form of a state park or wildlife management area, and would require some additional direction from the legislature if and when they appropriate funds. That's number one. Number two, I would ask the department to negotiate potential inclusion of FSC, that's Forest Stewardship Council, principles and criteria as a component of the purchase and sale agreement, and prioritize that inclusion in the management of older tree stands. I'd like the department to work with the proposers to clarify in particular the protections that could exist for old growth stands that are older than 250 years. And in order to keep the Common School Fund whole, I would suggest that the department could use any unexpended funds from the $25 million of bonding to secure additional enhancements of the existing conservation measures that are already part of the protocol. And finally, I would like the department to include in that purchase and sale agreement a right of first refusal for the 5 federally recognized Western Oregon tribes for any lands that the LLC might decide to sell after that transfer. So, Madam Chair, those are my best efforts to strike that balance in what I believe are our fiduciary responsibilities and what I would like to see as a continued public interest in the Elliott State Forest, and I appreciate you letting me make that motion.
Thank you, Mr. Treasurer. Before we vote on the motion, Treasurer Richardson, do you have any comments? And before you speak, I'll just let you think about this. We have 2 pages of testimony. I have multiple engagements scheduled over the next hour. I'm more than happy to stay here. I think over the last 2 years, the Land Board has agreed to listen to testimony, but I don't know where your schedules are, so I'm more than happy to cancel my schedule and stay here to listen to testimony, but I'm not going to do it by myself. So.
Thank you, Madam Governor. I am leaving from here to go to Portland Airport to fly to Washington, D.C. I appreciate the opportunity to comment on the proposed motion. I would like to take just a few minutes and help put in perspective what the Elliott Forest really is, because I really appreciated Treasurer Reed's use of the term undivided loyalty to the public schools. I want everyone to understand the Elliott Forest is not Shampooey. It's not Yellowstone. It's not Yosemite. When Oregon became a state in 1859, the federal government they essentially took all of our state and divided it up into sections or townships, and the townships are squares of 6 miles each, and each of those townships is divided into 36 squares or sections, and these sections are 1 mile apiece. So the federal government said, as part of becoming a state, we're going to dedicate 2 of the sections of each township to public education. They put it into a trust for public education. And then in the 1930s, a forester named Elliott helped to consolidate many of these sections that are all over the state into one place, and that became the Elliott State Forest. And so the Elliott State Forest is a trust, a land trust for the purpose of supporting education. And we, as members of the Land Board, are trustees over that trust. And so our trustee responsibility is to ensure an undivided loyalty to the Common School Fund and to public education. And so I wasn't here in August 2015. That's when the previous land board decided to sell the Elliott Forest based on the fact that it wasn't generating much revenue. And there is a responsibility to utilize this land trust for the generation of funds for education. And so I wouldn't have voted for it because the price that was ended up being placed on it was $220.8 million, which I think is too low. But it's what was put into the protocols, which was the offer to sell. And at that time, there were 49 different groups that came forward saying that they would be interested in thinking about it. I mean, some of them included the Nature Conservancy, I believe, was on it. Oh, the Audubon Society, the Eco Trust, the Sierra Club, the League of Conservation Voters. They all said, we might be interested in bidding on it. As it turned out, there was only one qualified bid that came in, and that bid was from the Lone Rock Timber Management Company, the Cow Creek Band of Umpqua Tribe of Indians, and the Confederate tribes of Coos, Lower Umpqua, and Siuslaw Indians. Okay, so we got tribes and Lone Rock, and they said, we can raise the money. They spent over $500,000 over the last 18 months complying with the protocols. And Department of State Lands has spent over $3.5 million complying with the protocols. And so here we are as trustees over this land trust, having a sale that's been offered in August of 2015 that has been accepted, and now we're being asked to change the terms. Now, like I said, I would not have accepted it because I don't think that would have been appropriate, but I can't change what happened in the past. So I believe that this would, that it's unethical to come forward now and to say we're just going to disregard what we offered. I think that if the protocols were met, the state is once again telling the tribes if they're not going to go, if we're going to go forward with this, that they would have a small amount of lands back, and it's kind of like saying 100 years or 150 years ago, you'll have this land as long as the rivers flow and the grass will grow. But now what are we doing? We're coming back and saying, but once again, the government is coming back and is going to change the terms. We're going to break the promise. And so I feel in a very difficult position because I am not in favor of selling the forest. And I would not have voted for it. But I'm a trustee of a land trust. And a deal was offered, and a deal was made. And in the way that I live my life, in the way that I was a lawyer, even if you shook hands on a deal, even if it turns out to be a bad deal, you keep your promise. And that it's up to the state to do that. So today we have a new land board, and we have a new treasurer, a new secretary of state, and the governor who was here made the decision in August of 2015 to sell it, and we're being asked to make a change. I think that it's our fiduciary duty as trustees of the Elliott State Forest to maximize the financial benefits for Oregon's 197 school districts. If the $220.8 million had been invested in the Common School Fund for the last 3 years, it would have generated $54 million. The return, thanks to the excellent staff in the Treasurer's office, has been 8.11%. And so if that cash was there, it would have generated that. But in fact, what has happened, it cost the school fund nearly $3 million just to maintain it. And so we're in this difficult position. I appreciate the attempt of Treasurer Reed to try and balance and protect to a greater extent the assets in this forest by making a modification in the protocols in the sale offer that was made. And hopefully these modifications would be acceptable so that we are not breaking a promise to the tribes and to Lone Rock. Thank you.
Please, there'll be no public comment from the floor. We have ample opportunity to take public testimony. Director Paul, could you please let us know what the legal obligation is regarding the protocol at this point in time?
Yes, Governor. I believe, I assume you mean in terms of what's the state's committed to under the current terms of the protocol and our obligations. The protocol itself does contain a couple of clauses germane to that question, one of which the protocol has language in there that does give the land board the right to terminate at any time. And I believe there's also language in the protocol that essentially lets participants know that actually I'm going to need to, if I could call, I don't want to misstate this because, as we said, we took months putting this together. If I'd like to bring up DOJ counsel Chris Matthews to be specific so that I don't misspeak and get the language correct.
Hi, everybody. Is this working? Okay, ice cream cone. I've got it right here, so I'll just read from it. But the gist of it is that did I hit the silence bar? No.
No,
okay.
You're fine. You're fine.
Okay. The gist of it is that there has not yet been an offer of sale made. This has been a process to identify a potential ownership transferee, and that process has led to the identification of someone. And throughout that process, it's weird to have that in my face while I'm looking through this. So where we are in that process is that we have done, for the last 18 months, a series of steps that involved identifying interested people, getting a price, which happened in last July, and then getting proposed plans submitted, which was what were submitted and looked at in December. And there was one proposed plan submitted, and it was deemed responsive. Now, so upon receiving responsive plans, there are a variety of steps that are coming up involving, first, the department making an offer of sale, which has not been made yet, and secondly, a negotiation of a purchase and sale agreement, which has not been made yet. And it's made clear in the protocol that until the time that both the state and the proponents sign a mutually negotiated purchase of sale agreement,
Which has not been signed.
which has not happened, hasn't even been created yet, there has been no agreement, and that it is clear that the land board may terminate at any time. And there's express language about the fact that the proponents are acknowledging this in a number of ways throughout the process.
Thank you. So at this point in time, I'll just state for the record that I am adamantly opposed to amending this protocol on the fly. I think I've been very clear that this protocol was developed after extensive legal consultation and careful consideration over a period of months. And my proposed suggestion is that we end the protocol so that we can discuss the number of, I think, 5 proposals that are now on the table that would amend the protocol. But I also believe that there needs to be a public option on the table. Given the critical importance of this matter, before we vote on the motion, I'd like to take public testimony, and I would ask that the...
Point of order?
Yes?
It was not, my understanding is that we have an agenda, and the agenda did not open for public testimony.
Given the importance of this matter, I'm the chair, and I believe it's appropriate that we take public testimony on this matter. Please, there will be no comments.
I would just like to comment that if your intention is to prevent me from making my flight,
I am
will
not
stay
go-
here and
I am not going to
stay
prevent you from making your flight. What time do you need to leave?
no later than 1 o'clock.
Okay. We've got plenty of time, I'm sure, to hear everyone that's here. So,
Thank you.
Treasurer Reed.
Madam Chair, I'm fine with testimony, and I will stay.
That's great.
I would just also comment that in regards to the protocol, it'd be my understanding that there wouldn't be anything to prevent the legislature, to your point about a public option, between now and when a purchase and sale agreement might be completed, for that public option to come from the legislature as well. There are obviously a lot of claims on our bonding capacity, but there's nothing to prevent the legislature from fulfilling that responsibility as well.
There's certainly nothing stopping the legislature from moving forward on a proposal. That is correct. All right. I would ask Mr. Kluting, Jane Kowalski, and Christina Hubbard to come forward. Please limit your testimony to 2 minutes. I think he's letting you take ladies first, so take it.
My name is Jane Kwiatkowski. I'm from Eugene, Oregon. On January 2nd, I sent you a letter in response to your call for ideas at the last board meeting. I included thoughts about the public land and some ideas for fundraising from the forest that keep it in public hands and do not involve logging. I yesterday sent an abbreviated version of that letter to both other members of the land board, and I'd like to read that in the interest of keeping things fast. So I wrote that first, I would like to make 4 points for preserving the forest in public hands. First, that it is a beautiful and unique environmental treasure that deserves to be protected for its own sake, just as Oregon's coast has been protected. When Governor Tom McCall signed the Oregon Beach Bill in July of 1967, he and the legislature were responding to public demand by declaring all of Oregon's beaches to be public property, protecting them from private development and providing for full public access. This action not only saved Oregon's beaches for all Oregonians, but also for all our Americans and visitors from the rest of the world as well. Second, it provides many benefits vital to our ecosystem. The old growth areas provide carbon sequestration, vital to reducing greenhouse gas emissions and protecting the climate at a rate greater than in any other kind of forest. It promotes increased water retention by soils, keeping water tables higher and protecting against erosion of the land. It protects streams and their dependent freshwater fish, as well as estuaries and shellfish beds downstream, and ocean fish like the coho and Chinook salmon. It is protection for many kinds of wildlife, including providing habitat for a number of endangered or threatened species. It is important to note that all of these natural benefits are occurring right now and will continue to do so without any additional effort or expense on anyone's part for so long as the forest is protected so that it can live as an intact natural system.
Thank you. I'm going to have you stop there. I had your 2 minutes, and I'll make sure you get the information to both of the land board members in addition to myself. Thank you.
May I take 5 seconds?
Sure. Go ahead.
The choice before you is stark. It is between liquidating the forest for a one-time lump sum of money, which will eventually be spent, and is not providing ongoing funding for the schools and serving undivided loyalty to the students, or saving the forest and its continuing natural benefits, ongoing jobs, and educational and recreational opportunities for all Oregonians by keeping it in public hands in perpetuity. Also to sell it...
Thank you. I'm sorry. Thank you. We want to make sure that everybody gets an opportunity to testify today.
Thank you. I'm Christina Hubbard with Forest Web of Cottage Grove. On behalf of myself and the members of Forest Web, I want to thank Governor Brown for her clear and hopeful plan to protect and preserve the Elliott with the goal of keeping it in the public trust. The number of jobs the current bid stated was 30 jobs for 10 years. This is insignificant compared to the hundreds of ongoing jobs that could be generated by responsibly developing and managing the Elliott using an ecotourism model. Well-planned ecotourism can provide the following: increased local employment and income throughout the year, greater diversification of economic activities, opportunities for locally controlled ecotourist-related businesses. And there are published works already out there. I've cited them in the comments. I have turned in written work that can be resourced to help develop a plan that would maximize the benefits to local communities and minimize negative environmental impacts, conserving fragile habitats and endangered species while increasing benefits for local residents by creating sustainable tourism. I urge both of you not to sell this land. Don't give it away for any price. As you said, Governor Richardson, it's worth a lot more than $225 million. And again, I've been here all through this process, begging for a way to save this forest as a volunteer. I know you guys are new to this game, but there's a lot of us in this room that have been fighting this for a long time and want to save this forest because in its own way, sir, it is just as precious as Yellowstone or Yosemite. Spend some time down there, hike there, see it for yourself. There's something special there.
Thank you. Mr. Kludig.
Thank you, Madam Governor. Brown, Secretary of State Richardson, Treasurer Reed, thank you for this opportunity. We've been in this fight for a long time. I appreciate the efforts you did, Governor Brown, when you were Secretary of State on the previous land board. We come up with a good, sound agreement for the benefit of the state, and most importantly, the benefit of the kids, following the Constitution. 45 million, up to 45 million was the...
Bill, can you speak directly into the microphone? Get closer.
45 million feet was the agreement. And we knew we was going to have a hardship, and we did. The appeals were immediately filed, and to the disappointment of a lot of people in this state, our Justice Department refused to fight it. This forest has turned into a very expensive forest. I wear my jobs pin every day. We could have jobs in that area, helping the counties, again, the schools. We have to move forward on this. We can't let this forest problem drag on. We need the timber off that forest. We have mills right there in the local area that are trucking in logs from out of state and out of this country to keep the mills running. I got 1,400 members that have been waiting on this forest for the last decade. Thank you.
Thank you, Bill. Next up, Wendy Hoffman, John Peterson, and Claire Klock. And I'm sorry if I'm mispronouncing your names. I'm doing the best I can with your handwriting.
Madam Chair, might I suggest you tell the next group?
Great. On deck, we've got Diane Schauer, David Gold, and Brad Raffel. Go ahead. Please state your name for the record.
Hi, my name is Wendy Hoffman, and I want to thank you, Governor Kate Brown, for your alternative vision and the willingness that it's been expressed to work with the tribes. I asked you before, and I would just appreciate it if you could reiterate how realistic is it to revise a version of Measure 97 or a stepchild thereof to aid in the decoupling of the school fund from the forests.
Thank you.
That's it. Thank you.
Thank you. Mr. Peterson. Oh, sorry.
Oh, well, okay. Thank you, Governor Brown, for letting me speak here, and thank you for standing up for our public forests, and thank you, Peter Courtney, for standing up as well. I support and will work with you to keep the Elliott State Forest in public hands. I support sustainable timber harvest on some portion of the forest. I support a bonding measure to retire the most environmentally sensitive portions of the forest. I also support the efforts of the Cow Creek Band of the Umpqua and peoples of other First Nations to regain ownership of their ancestral lands. I believe one of the most valuable outcomes of this process has been highlighting the legitimacy of the tribes to their rights to their ancestral lands. and hopefully that can be addressed at a later date. With regard to Mr. Richardson's comments, you yourself stated that the deal is bad. The forest is worth far more than $220 million. The deal is not complete. Let's scrap the deal and not get taken. With regard to Treasurer Reed's proposals, I'm particularly concerned with the $25 million repurchase idea. It just seems crazy. I know we're going to get taken advantage of. We're going to pay a premium for a pittance on that rebuy. Let's not sell the land in the first place. Thank you very much.
Thank you. And is it Claire Clock?
Yes, Claire Clock, Corbett, Oregon, and I've talked a number of times here on the issue, saying that it needs to be cut in a reasonable fashion, that it all needs to be thinned, or as far as the timber sale. But let's just talk about the $221 million. $221 million, what is that? 1-2 years for the Common School Fund, and then it's nothing. It's nothing as far as in perpetuity for the school people or school kids of Oregon, and it's nothing for the public that may be eliminated from those public lands, like we see happening in other states and in this state, where the state government pays up to $5 to $9 an acre for habitat and access for hunters, anglers, and that's not even for hiking, mountain biking, fishing. So the best possible use for this is in state and public ownership, and it's just not a good deal financially at $221 million on a sustainable type of land like this. This will produce time and time again. So we will more than get back to that. So whatever procedure you can do, think about that particular one. Thank you.
Thank you, Mr. Clock, Mr. Peterson, and Ms. Huffman. We have up next Diane Schauer, David Gold, and Brad Raffel. On deck, I'm not sure my baseball metaphors are appropriate, but on deck we have Ross Tewksbury, Josh Laughlin, and Bob Zybeck.
Hi, my name is Diane Schauer. I live in Portland, and I also cannot read my handwriting. So if this is a little disjointed, please forgive me. The election of Donald Trump and his choices for his cabinet paint a dire picture for the future protection of public lands. It is not unreasonable to speculate that many, if not all, federal environmental protections that are now in place for the Elliott State Forest will be compromised or eliminated by his administration. It's also possible that President Trump's administration will do nothing to counteract climate change. Any measures that are taken will most likely be at the state level. It's up to the state of Oregon to protect its economic interests and protect its citizens from the effects of climate change. As Governor Brown has mentioned, the Elliott State Forest as a carbon sink can be a key part of this. If there is a bright side to a potential loss of federal environmental protections, it is that these areas could now be used as carbon offsets and thus generate more revenue. There is more than one way to protect our children. Climate change is going to be devastating to the next generation. It is up to us to protect them from this. As a state with a history of progressive politics, Oregon has a chance to show that indeed things are different here. With so many Oregonians concerned about the future of our country and our state, keeping the Elliott State Forest and public lands will send a message that we are true to our values. And in terms of education, the goal of education is to teach children to think critically. What are they going to think of us when they critically look at us if we sell the Elliott State Forest? Finally, what is going to happen when the money from the Elliott State Forest is gone? What's the next stopgap measure? We all know that funding for public schools is antiquated and needs to be changed. It is up to us to do this. Thank you.
Thank you. Go ahead.
Thank you to the board. My name is Brad Raffel, and I'm the president of Conservation Capital, and we're a company that basically seeks investments that put together traditional timber and other natural resource activities with conservation attributes, and there are new markets seeking to protect those ecological assets that are really only a few years old. So our vision for the Elliott and the original protocol didn't quite really work for our model, but it could be amended if that's the decision to make it work. would entail the following: an upfront payment of the acquisition price in cash to the state would be, of course, from your interest, important, with a long-term goal of protecting as much as half of the Elliott's current acreage with old-growth forest over the next many years. Number two, there would be full public access today, as it is today, to the forest in perpetuity. Number three, and important, the forest itself would remain in public ownership. We would not, as a result of the investment, take fee title, but we, of course, would assume the ability and the right to monetize the various ecological attributes that the forest has, but we would not have public ownership. And lastly, we would pursue revenue from several different sources out there, and those sources of revenue that we would seek would, A, be collection of the value of the ecological services, carbon, water, and a variety of other services that we think are monetizable, and that's new today. It wasn't true in years past. Number two, of course, would be forestry operations, seeking to capture the value and the jobs that go with forestry at the forest. Number three, we want to explore the possibility of using the Elliott's logs for CLT or other engineered wood products, something that I think Oregon needs to pursue aggressively. Number four would be the bond revenue we are talking about here today in order to pay for the public access and ownership of the forest. And then lastly, we would like to be able to at least explore recreation, educational, and ecotourism funds. That's our idea.
Thank you very much. David Gold.
Thank you, Governor, for
Thank
having
you.
me. Can you hear me?
Yep.
Thank you very much. I'm here for the children of Oregon. The trust has been taken. There's $220 million take, and I believe that Oregon needs to go after the federal government and get that money. That could fund all this stuff you want to do. And that's very legal that you could do that. And then the other thing is, I think you ought to, the north half of the forest, like from the 7,000 to the Umpqua River, could be retained for your old growth forest and so forth, and then the rest of it can be for the children. And then I believe the Coos Indian tribe ought to be able to take care of the riparian zones, and you can work out an agreement with them to do that. But I want to stress that I'm talking for the children, and we're with associates of David. Advocates for school trust lands, and that they believe that this is a legal issue, and that take needs to be legal action be taken against that. Thank you very much.
Thank you very much. We have about 10 minutes left, so I'm going to invite up Ross Tewksbury, Josh Laughlin, and Bob Zybeck. Please, if you can keep your comments to under a minute, that would be really helpful so we can get on everyone that's signed up to testify.
I'm Ross Tewksbury, and I'm from Washington County between Beaverton and Portland. And I'll try to keep this brief, but I support Governor Brown's position on this. And I think it should be in public hands as far as, but I do support the, Native American rights also. And also I'm not totally against any kind of, logging on that. But I really think there has to be some kind of a decoupling of the school thing from the conservation thing, because that's like a no-win thing. If either the schools lose or the conservation loses, or, or the jobs lose. And I would just try to implore Secretary Richardson, think back that I really think that conservation and preservation are really some conservative values, in that many Republicans, just Paul Hanneman, Vicki Berger, Tom McCall, just for examples, have been strong, advocates in these areas over the years, and it's always been, a bipartisan thing until just the last, recent years here.
Thank you, Mr. Tewksbury. We need to move on.
Okay.
Thank you.
Thank you for this opportunity. Happy birthday, Oregon. I'm Bob Zyback from Cottage Grove. I'm representing 97-year-old Wayne Giese, who's busy at another meeting right now. For the last several decades, Wayne has proposed management policies for our federal lands that would put people immediately to work, would retain large amounts of old growth, far in excess of what's being promoted here, 40% instead of 25% of the Elliott, and would maintain and encourage recreation for all Oregonians, would experiment with the methods of managing by old growth habitat versus active logging for a 20-year period, and would make everybody in the state aware of what's going on. So the Giese plan is an alternative, we think, that addresses all of these problems and results in educational opportunities as well as income for our schools. And you've all got a copy of the proposal, and you've got a copy of the 13-page report I wrote 23 years ago in which these exact same problems were being discussed at that time on the Elliott.
Thank you, Bob, and thank former Representative Giese for us. Josh.
Governor, members of the Land Board, my name is Josh Laughlin, Executive Director of Cascadia Wildlands. First off, I'd like to thank the Governor for her vision she put forth in her leadership last Friday on finding a resolution for the Elliott that keeps it in public ownership or tribal ownership and makes the Common School Fund whole. So we appreciate that. At the December Land Board meeting, the Governor requested a Plan B. We've spent the better part of the last 2 months deeply exploring options that would keep the Elliott in public or tribal ownership while also making the Common School Fund whole. We have a path forward, so I appreciate you allowing for this comment opportunity this afternoon. You heard a bit from Conservation Capital just a bit ago. We believe there's a way to leverage the bonding authority that was discussed, coupled with commitments to enhance or preserve the forest's ecological services, payments for carbon clean water banking, including timber revenue on the Elliott and the existing plantations, and also revenue from the conversion of logs into potentially a cross-laminated timber facility down around the Coos Bay Reedsport area.
Thank you, Josh. You can certainly submit the remainder of your comments to the Land Board members.
Can I say one real quick thing
Sure.
that I'm not certain both new Land Board members are aware of, and that's ORS 530-450, which actually withdraws from sale the Elliott State Forest. The statute's currently subject to ongoing litigation in the Oregon Court of Appeals. Our view, it's illegal to sell the Elliott State Forest. I just wanted to make sure the new Land Board members were aware of that.
Thank you very
Happy
much.
birthday, Oregon. Keep it in public ownership.
Pam Driscoll, Renee Weiss, and James Barber. And I'm sorry, those are probably going to be the last folks that we have time to testify. I want to provide ample opportunity for deliberation by the Land Board members and their comments.
Hi, I'm Pam Driscoll. I just got unnervous because I thought I wasn't going to be able to speak. So here I am again, nervous. First of all, I want to say just because a lot of time has been planned for something isn't a reason to vote for it. If we were voting for a world annihilation, I don't think we'd say, well, there's been a lot of time planning for this. So that, to me, is not a good argument. Undivided loyalty to school children. I'm a teacher of special needs kids. I've been working with kids for over 30 years. I have undivided loyalty to all children and future generations. And one thing we can't do is get the land back after it's sold. So it makes no sense to me to rush through and make such a major decision to sell this valuable, irreplaceable property, forest, for short-term gain. Once it's done, it's done. It's a done deal. The value of this land will only increase with time. The damp coastal forests have a greater chance to survive than other forests inland. So with climate change happening, this might be one of our prime and only really surviving, thriving forests as time goes on. I've also been researching climate change for 25 years. To sell the Elliott State Forest on the anniversary of the beginning of Oregon on Valentine's Day would break all of Oregonians' hearts, including our former governor, Tom McCall. This could be a day to be happy about and be proud of, or it could be a day of shame. That's all I have to say.
Hi, I'm Rini Weiss, and I'm part of the Benton Forest Coalition in Corvallis, Oregon. And I'd like to say that the Elliott Forest, the old-growth Elliott Forest, which is approximately 50%, is now what I would consider an endangered species. All the forest itself is a living ecosystem, and we do not have other ecosystems in this state of that size, a coastal temperate rainforest. The species that live there depend on this, and I just like to look at that as an endangered species as a whole ecosystem. I'd like to acknowledge that the public sector, myself included, has put many hours and many people in this room, years and years of their life into the thoughtfulness of this forest, and the monies they have put in, we don't have the answer to, but you guys have been able to say this, the timber company put this many hours and this much money. Well, I want it to be acknowledged that we have put, hundreds and thousands of dollars and hundreds of thousands of hours into this as well. Thank you.
Thank you.
Do you have time for the tribes to be able to speak?
Sure, go ahead.
Thank you. I'm James Barber from Lane County. What we've heard today, the land board can halt the sale of the forest at any time according to the protocol that's in place. I can appreciate being in the position of continuing a process that was begun by your predecessors, but with all due respect, Secretary Richardson, there is no handshake deal guaranteeing the sale of these lands to the winning bidder unless it was made behind closed doors. There is no sale of contract currently in place obligating this board to continue with a sale that is adamantly opposed by millions of Oregonians. If you truly would have opposed this sale, as you claimed moments ago, you can stand with Governor Brown and stop it with a clear conscience. Treasurer Reed, I voted for you this past November. What I've heard of your timid proposal so far leaves me very disappointed. We thought we were electing a strong Democrat who would fight for the people. I do have hope that you can be that person. Your decision today will be remembered. Please make the right choice. Listen to your constituents here today and stop this sale. Governor Brown, your efforts on behalf of the people on this issue have been exemplary. We stand with you today as you have chosen to stand with us. Thank you very much.
Thank you. All right. I'm sorry. I took people in order. Chief Brainerd is here, as well as I know there are folks from the members of the Cow Creek tribe, and I wonder, Chief Brainerd, if you wish to speak at this time. You don't have to if you don't want to. Come on up to the mic if you're going to speak, though. Thank you.
I just want to say that I understand and realize that the land board has a difficult and hard decision to make, and that because that is our traditional homeland, the tribes are interested in anything that goes on within there, and we will continue to be no matter what decision comes.
Thank you. Thank you very much, Chief Brainerd. Is there anybody here from Cow Creek wishing to speak?
Yes, but we'll decline.
Thank you very much. Okay. You can certainly submit your testimony in writing. All right. At this point in time, I'm going to cut off public testimony and turn it over to the treasurer for his motion.
Governor, I think I made my motion. Do you need to be
Would
restated
you repeat
fully?
it, please? Yes.
Okay. I move that the land board continue to pursue the protocol with three amendments, or an amendment in three parts, which would first be to include in any potential purchase and sale agreement the ability of the state to repurchase by June 30th, 2018, or within 90 days of a transfer being completed from the Elliott Forest LLC up to $25 million in acreage. I'll get closer. It would allow the state to repurchase up to $25 million in acreage land that provides key conservation habitat. Ideally, that acreage would be placed in a conservation structure that would allow for continued recreational, hunting, angling, other forms of public access could be in the form of a state park or a wildlife management area and would require some more specification from the legislature if they decide to appropriate those funds. Second, the department would negotiate potential inclusion of Forest Stewardship Council, FSC, forest management principles and criteria as a component of the purchase and sale agreement, with particular priority on inclusion of those standards and criteria in the older stands. The department would work with the proposers to clarify the protections, particularly for old growth stands that are over 250 years old. And in order to keep the Common School Fund whole, the department could use any unexpended bond funds from that $25 million to secure additional enhancements of existing conservation measures, or a variety of ways that might make sense. And finally, the department would include in that purchase sale agreement a right of first refusal for any of the 5 federally recognized Western Oregon tribes who might wish to purchase land if it's put up for sale eventually by the LLC. Again, at the risk of sounding repetitive, I don't make this motion out of with any particular sense of celebration. I'm not happy that this is the constraints under which we operate, but it's my best attempt to try to balance what I view to be my obligation as a fiduciary and to live up to our undivided loyalty requirements to school kids in Oregon.
And my understanding is that this motion also provides the director with the discretion to ensure that these supplemental amendments are not, or to address any underlying contradiction that there may be in the protocol. Is that correct?
Yes, thank you for the clarification.
Thank you. Anything
Madam
else?
Governor, there is one clarification.
I'll give you. Go ahead.
A
Treasurer Wheeler.
clarification.
Please.
In the first time that you made the motion, I believe that you said by June 30th. And this time I don't think you made that. You included a date. Was that intentional?
I did both times, actually. But yes, June 30th, 2018, yes.
Okay,
or within 90 days of a transfer occurring.
Okay. I'm sorry I missed that.
No problem.
Any other questions? Any further discussion on the motion? Lorna, would you please call the roll?
Aye.
Aye.
Brown votes no. Motion passes. So I believe that concludes most of the business to become before the land board today. I do believe very strongly that we should not be bound to a single proposal, and that I am going to go ahead and direct the department and the director of the Department of State Lands to consider a public ownership plan going forward and present the results at the next state land board meeting. So, thank you.
Madam Governor, that wasn't the motion that we just passed.
I understand that. I'm directing the director of the Department of State Lands to also consider a public option moving forward and to bring those back to the land board for discussion in April.
Point of order. I move to override the direction you just gave to the director because it's contrary to the motion the land board just passed.
It is not contrary to the land board motion that just passed.
I make that motion.
Is there a second for the motion? There's no second to the motion. All right, thank you. No, you may not. Okay. Anything else come before the meeting? We are now adjourned. Thank you very much.